Meetings are resumed. Please be seated. When we rose for lunch, two members had indicated their desire to ask question of the Honorable Minister of Education, the member for Newlands, Savannah.
Thank you very much, Mr. Speaker, for allowing me to understand in order 32. First of all, I want to commend the Minister of Education on all of her things that was pointed out, but specifically in the Department of Education, additional staff to support students with special education needs. And I just wanted to say a reminder to her. I know some time ago at specifically the Savannah Primary School, some of the kids there were having some difficulties, and also if she could have her staff check to see if the problems are being adequately addressed. Thank you.
Honorable Minister.
Thank you, Mr. Speaker, and thanks to the Honourable Member from Savannah for his kind sentiments. I can also give an undertaking that we will do a more recent check with Savannah to find out exactly what obtains there. I know that some preliminary checks were done, and what the minister's alluding to have found to be so, and the department was trying to see how they could remedy some of the issues, but I'll do a current check and revert to him ASAP. Thank you, Mr. Speaker.
Member for Georgetown Central.
Thank you, Mr. Speaker, and I too stand on Standing Order 32. I appreciate the leeway. I just want a clarity from the minister's statement on page 7 of 9. On the bottom paragraph, the sentence it says, the property, and it's under the heading of Scranton Community Park. Sentence reads, the property was purchased for a consideration of $272,500, and in brackets it says exactly in Cayman dollars, from the owner, I don't want to say her name again, for the purposes of continued use as a public community park after EA4 purchase of land appropriation was increased. Can I take that, Mr. Speaker, as the minister saying that the only reason why they bought it, or one of the prerequisites of it being sold, was on the purpose of it only being for a community park?
Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, it's entitled Scranton Community Park. So that was one of the reasons why the members from Georgetown that made the representations communicated that they wanted to purchase the park, but there were other reasons. It's annexed to Crown property already in central Georgetown, and it was also becoming derelict. Government had owned Crown properties annexed closer than even the government administration building, and with the government owned it, you didn't have to go through the enforcement notices, etc., to have it clear up. And because the government is keen to have the revitalization program up and going in Georgetown, this was but one of many projects that would complete that objective of the government.
Just one more, Mr. Speaker, thank you. For clarity, is the government then saying that they would be willing to give the community, Georgetown Central Scranton Committee, which is a non-profit organization, a peppercorn lease to operate that park down there, which have been operating it for the last 2 decades?
Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, there is a tried and tested methodology for application for lease. If it's 5 years or less, it comes to my ministry and goes to caucus and the cabinet for due consideration. If it's anticipated to be in excess of 5 years, because it's Crown property and includes vesting of sorts, it would come to this Honourable Legislative Assembly. So the government would indicate to the member asking that that process has to be followed, either on his conveying it to the non-profit community in Scranton Park, or they themselves directly coming through that route.
Last one.
Georgetown Central.
Thank you, Mr. Speaker, for the leeway. I just want to instruct the minister that that process will be started, and I hope that when it reaches the cabinet and potentially to the Honorable House here, that all members give us its full support, as it's something that is important to the community upon which I represent, and we hope that we will get a peppercorn lease from the government so we can turn that park into what it truly deserves for the community members of that area. Thank you, Mr. Speaker.
Honorable Minister.
Mr. Speaker, I'll take the liberty to thank the member for his expressions of concern on behalf of his community, but to note that it's noted, and I will resist the temptation to elevate it to one of instructions to the minister and my government.
Next item. Honorable Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, I rise to provide an update to the members of this honorable House on the admirable progress and the government is making with the green iguana culling program. Mr. Speaker, the government has been working on a solution to address the problem that the invasive green iguanas are causing for our country. Each member of this House is acutely aware of these issues, as our surveys and research has shown that these invasive pests are presently in every district in the Cayman Islands, although the vast majority of green iguanas are in Grand Cayman, with larger populations in the district of Bordentown, Georgetown, and West Bay. Mr. Speaker, in May 2018, the Department of Environment completed the outline business case for the Green Iguana Culling Project, which is required by the Central Procurement Office, and a requirement of the procurement law to justify the use of government funding for such a large undertaking. In August 2018, Mr. Speaker, before the cull project began, our green iguana survey indicated that the green iguana population in Grand Cayman was between 1.1 million and 1.6 million green iguanas. During the week of 15th to the 19th of October 2018, the DOE conducted a color registration which attracted a massive response from all sections of our society. During the registration period, green iguanas cull training was provided to NICE participants. Educational materials and discussions were held with every registering culler, and each registrant signed an agreement with DOE and with the cull manager. After the registration period was finished, it was revealed that 349 cullers, that is persons and businesses, were registered. Mr. Speaker, the contract with the cull manager, Cornwell Consulting, was signed on the 19th of October 2018. Culling of green iguanas began on the 29th of October, and within the first week, cullers delivered over 53,000 culled green iguanas to the landfill. That equates to an average of almost 9,000 iguanas per day, 3,000 more than the requested average of 6,000 per day for the first few weeks. In the second week of culling activity, cullers delivered another 39,000 plus iguanas to the landfill. This is more of what we are expecting to see, Mr. Speaker, an average of approximately 6,000 green culled iguanas per day for 6 days of culling per week. Going into week 3, as of Wednesday, 14th of November, A further 19,000 green iguanas were culled and delivered to the landfill. Mr. Speaker, this makes a grand total of 112,000 green iguanas that have been culled in the first 2.5 weeks of the project. But we need to remember that this is just the tip of the iceberg for the estimated invasive green iguana population on Grand Cayman, and there is still an estimated 90% remain to be culled. Mr. Speaker, at the start of the cull project, we had some small issues which are not totally unexpected with a project of this magnitude, but the DOE and the cull manager were able to resolve these issues very quickly. One of the main issues at startup was the illegal dumping of carcasses after removal of heads by irresponsible cullers who found it convenient to store iguanas culled before the program officially started. Heads-only deliveries have now been discontinued, and that issue has faded away. We have also received some reports of dangerous or illegal use of air rifles and trespassing on private property, and the DOE are liaising with the Royal Cayman Islands Police Service and the cull manager to try to identify and revoke registrations of what we believe is a small number of cullers violating terms of their registration agreement. Mr. Speaker, we are still in the early days of the cull project, so we do not yet have detailed information, number of active cullers per week or month, district most culled iguanas taken from, any observed trends with, whether cullers are teaming up, or efficient cull methods, air rifles versus snares and sticks, or day versus night, or other trends observed in the culling project. However, our early indicators appear to show that most of the culled green iguanas are coming from the 3 districts of West Bay, Georgetown, and Bordentown, in no particular order. Our database also shows that there are at least 26 NICE workers who registered with us that are now active cullers, but there are likely more than that in total who are working in the culling project but not actually registered, perhaps as auxiliaries to a registered culler. We are now processing the invoice payment to the green iguana cullers for the first week of the culling project, which will be paid to the cullers on the 16th of November, 2018. Payments will be made every 2 weeks thereafter in arrears. In that same invoice will be a payment to the management company, Cornwall Consulting, for their project, administration, landfill operation, variable costs due to the high delivery rates, and expenses related to final setup of the iguana reception site. Mr. Speaker, in order to properly supervise the cull manager and the payments being made to the cullers and the manager, the steering committee requires that the cull manager issues receipts every time a culler brings iguanas to the landfill site. A copy of each receipt is then sent to DOE, and one is retained by the manager. When an invoice is submitted, the DOE cross-checks the receipt with the invoice. The manager is paid a sum for management of the project, which comprises a monthly base rate and a rate for every additional 2,000 green iguanas processed. The manager also bills us for every green iguana culled, but this amount simply passes through to the cullers. We should also mention, Mr. Speaker, that there are 2 security cameras on site that allow us to monitor the cull project management from time to time, and the DOE has also been conducting spot checks. The steering committee has begun its regular meetings, which will continue throughout the project as a means of ensuring regular communication with the cull manager. Mr. Speaker, we are receiving more iguanas than initially expected, but this probably reflects the easy culling opportunities, and we expect the green iguana delivery rates to settle down close to our estimated of 6,000 per day before gradually declining as cullers hit diminishing returns for their efforts. At this stage, Mr. Speaker, our strategy looks solid, but it is still very early days to judge whether changes may be needed down the line. The cooperation with the culling project between the DOE and the other government agencies like DEH, the RCIP, and the Department of Agriculture is working very well, and we expect that this continue throughout the life of the culling project. For anyone seeking the latest information on the culling project, they can simply go to the DOE's website at www.doe.ky for the most up-to-date statistics on the green iguana culling project. All in all, Mr. Speaker, even though it is early days, we have a good team in place at the DOE and a good project manager and good partners in other government agencies that will see this project through to the end. I wish to thank them for all their hard work and dedication with this project to get us to this point. On behalf of the government, I want to thank them all and let them know that we appreciate all they do to make a meaningful difference in the lives in the protection of our precious environment. Mr. Speaker, you can't go without saying that we need to thank the Unity government for taking the time and all the efforts that we put in trying to ensure there were many versions of the culling program that came to us as a government, and many were sent back because us as a government was not happy that the maximum amount of persons would have been able to participate in this program. The program that we have now, I won't say that everyone is satisfied, but it seems to be working. And we moved with the approach that the program should be given an opportunity to succeed, and we continue to move forward, but only after evaluations are done at the end of this budget cycle as to the success of this actual campaign till the end of this year. So DOE has committed, the ministry has committed to report back to caucus and cabinet all the findings before we move forward with this like project in 2019. Mr. Speaker, thank you for giving me this opportunity to update the members of this honorable House on the green iguana culling project. I eagerly look forward to providing further positive updates at the next sitting of this honorable House. Thank you, Mr. Speaker.
Clark.
Next meeting of this honorable House, Mr. Speaker.
Next sitting would be, the next sitting of the Honorable House will be on Monday. Yeah. Next meeting not announced yet, not decided yet. Next meeting, next sitting will be on Monday, God willing. Clark? Oh.
Personal explanations,
None.
obituary and other ceremonial speeches,
None.
raising a matter of privileges.
None.
Government business, bills, first reading, the Prisons Amendment Bill 2018. First reading. First reading.
The bill has been deemed to have been read a first time and is set down for the second reading.
Second readings, the Evidence Amendment Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker.
Soon.
Mr. Speaker, I beg leave of this Honorable House to move the second reading of a bill, the long title of which is a bill for law to amend the Evidence Law 2018. 2018 revision to modernize the law in respect of the rules of hearsay evidence and witness statements and for incidental and connected purposes.
The bill has been duly moved. Is the Honorable AG speaking there too?
Thank you, Mr. Speaker. Yeah. Mr. Speaker, this is a fairly short bill, but I must confess that the issues raised in the bill is a fairly technical one, and so, Mr. Speaker, I will endeavor to help assist the House in navigating the clauses in the bill, Mr. Speaker. Mr. Speaker, with the passage of time, the law relating to hearsay evidence and certain witness statements have become outdated. Mr. Speaker, hearsay evidence, in plain speaking, is one person in court attempting to repeat something that someone else might have said outside of court. The person in court trying to repeat that and to give the impression that it is the truth of what transpired without the person being aware, personally aware of the fact stated in that assertion. So, Mr. Speaker, it has become necessary to amend the evidence law to modernize it so that it is consistent with current thinking in the common law world, as well, Mr. Speaker, as with the statutory changes made by the Criminal Justice Act of 2003 in the UK. The simple objective here, Mr. Speaker, is to modernize the rules in respect of hearsay evidence and witness statements in order to further enhance the administration of justice, Mr. Speaker. To this end, the bill seeks to amend Section 18 of the Evidence Law by replacing paragraph B, which currently, Mr. Speaker, removes the prosecution's ability to comment where an accused person does not give evidence in his hearing, in his trial, or her trial. It will therefore correct, Mr. Speaker, an anomaly in the current law which permits the judge and the defense counsel, but not the prosecutor, to comment where an adverse inference may be drawn because of an accused person's silence at a trial. Indeed, Mr. Speaker, There's no need for paragraph B in section 18 of the evidence law, given that the issue of adverse inference is now dealt with in the police law, Mr. Speaker. Mr. Speaker, the bill also amends paragraph D of section 18 to provide that a defendant who chooses to attack the character of any person who is not called as a witness and who is not therefore in a position to defend themselves against any such attack, or, Mr. Speaker, defendant who chooses to attack the character of any other person, including those who are called as a witness. And where he does so, that defendant does so, Mr. Speaker, with the intention of not himself giving evidence in order to shield his or own bad character from exposure, then, Mr. Speaker, this law is saying that he may now have his own bad character exposed to the court. So, Mr. Speaker, if a person is being tried and he attacks a witness, credibility, or attacks somebody's credibility, and then chose not to give evidence at his trial, what the bill is saying is that the court may allow evidence to be given about that other person's bad character. The bill amends Section 33 of the current law, Mr. Speaker, to provide a definition for the word fair in circumstances where the court has to consider admitting the statement of a person who is said to be in fear. It provides that fear, Mr. Speaker, must be widely construed and includes fear of death or injury of another person, or, Mr. Speaker, financial loss. Mr. Speaker, this particular provision, or this provision is particularly helpful in instances of domestic violence where a spouse will make a complaint to the police. There is evidence of injury, trauma, blood, and cut and wounds. And then, Mr. Speaker, 6 weeks later, or 6 months later, the victim refuses to give evidence out of fear, Mr. Speaker, that he or she might be further injured, or, worse yet, Mr. Speaker, the spouse who is the alleged perpetrator threatened to cut off financial support for not only, in this say a female, not only the female, but financial support for the children as well, Mr. Speaker. Those are some of the kind of fears that will cause a, if I might say, a battered wife or a battered spouse to make a calculation as to whether or not to continue with a case. And if the economics of it doesn't add up, Mr. Speaker, out of fear, huh? That's a spouse, yeah. That's a, right. And then later, thank you. So it can happen, Mr. Speaker, either way. So the victim can be a male, the victim can be a female. The perpetrator can be a male, the perpetrator can be a female. So it happens both ways. Mr. Speaker, the bill will insert new provisions, namely sections 33A to 33H, to deal with the use of documents to refresh memory. It also deals with inconsistent statements, previous statements of witness, additional requirement for admissibility of multiple hearsay statements, documents produced as exhibits, and credibility, Mr. Speaker. It also deals with issue of stopping the case where evidence is unconvincing and the court's general discretion to exclude evidence. These provisions, Mr. Speaker, will bring the law in line with recent developments in these areas. Mr. Speaker, if I might be a bit more granular, the proposed Section 33A provides for a statutory mechanism to enable a witness, whilst giving evidence, to refresh their memory from their previous statement. Mr. Speaker, this is particularly helpful where there has been a long passage of time between the incident they seek to recall and the trial. Mr. Speaker, just by way of example, it's not unusual for an incident to take place and the trial comes on 2 or 3 years later. And invariably it comes down to a test of memory and the ability to recall. And the human being what it is, Mr. Speaker, it is likely that you will not be able to recall certain events. So what this is saying, Mr. Speaker, is in those circumstances, the court has the discretion to allow the witness to look at his or her statement, refresh his or her memory about what that person may have said in the statement 3 years ago. Mr. Speaker, it should be about being able to speak the truth and give an accurate account rather than a test of memory or the test of the ability to recall. Mr. Speaker, the proposed Section 33B provides that where a person has made a previous inconsistent statement, the contents, Mr. Speaker, if admitted, are admissible for the purposes of proving the truth of that statement. Currently, Mr. Speaker, a previous inconsistent statement could only be used to question the credibility of a witness. This provision statutorily removes the rule. Again, Mr. Speaker, by way of example, so that honorable members can follow. If during a trial, it turns out that the witness in his or her statement says that the assailant was wearing a red shirt, and it is proven, Mr. Speaker, that there was, let me just start again, I lost my trend, sorry. If an incident took place, Mr. Speaker, and the witness gave a statement to a police officer to say that at the time of the incident, the accused person was wearing a red shirt. 3 years later, or 2 years later, the trial comes up, and the witness in the witness box says the accused person was wearing a white shirt. Clearly, Mr. Speaker, there's some inconsistency in that. And the question is, how do you treat with that? What currently obtains, Mr. Speaker, is that counsel will simply ask the witness, did you, on the previous occasion, says that the person was wearing a red shirt? And the person might say, I didn't say that. The witness might say, I didn't say that. And the counsel will be able to ask the court, after laying certain ground rules, ask the court can I show the statement to him or her, to the witness, to prove what was said earlier on in the earlier statement. The court, Mr. Speaker, may allow counsel to show the statement to the witness. Would ask the witness, is that your statement? Yes. So you recognize your signature? Yes. And on that statement, in that statement, did you say that the person was wearing a red shirt? And the witness will say, it is in my statement, so that was what I said. However, Mr. Speaker, that is all the use that can be made of that statement. The fact that the person might say it was a red shirt does not form part of the evidence. It is really just being used to question the credibility of the witness, because the next question from counsel is going to be, where they say it's a red shirt, now you say it's a white shirt, which is correct? It can't, both assertions can't be correct. And the witness might say, well, I am insisting that it's a white shirt. And all that is left, Mr. Speaker, is for later on in the trial, for counsel to, in his address or something, says that the witness can't be believed, can't be reliable, because he made an inconsistent statement. And so, what this is saying, Mr. Speaker, is that the statement could now be admitted in evidence as proof of the fact that the person did say in an earlier statement that it was a red shirt that was being worn at the time of the incident. Mr. Speaker, the proposed Section 33C provides for other circumstances in which previous statement may be admissible to prove the truth of its contents. For example, where a witness is accused of recent fabrication. This provision also statutorily removes the rule that a previous inconsistent statement could only be used to impugn the credibility of a witness. Again, Mr. Speaker, by way of example, if during a trial, same trial, a witness said the accused person shouted expletives at me when he accosted me, it is in that person's witness statement when he gave that to the police. But during cross-examination, during the trial, the person might repeat that assertion, which is that the accused person shouted expletives at me when he accosted me. Defense counsel might say to him, that did not happen. You just making that up as you go along. You just making that up whilst you give your evidence in the witness box today. You didn't say that to anybody before. Why didn't you tell the police that? The prosecutor would be able to say to the court, Mr. Speaker, well, before we get to that, the defense counsel would go on to say, you are making it up, you are fabricating the evidence against the accused person. Those are the usual expressions. Prosecutor will be able to get up and say to the judge, my lord, it is incorrect to suggest that the witness is making it up as he goes along. The witness had said so on a previous occasion. As a matter of fact, when he gave his initial statement to the police, he did mention in that statement that the accused person had used expletives to him when he accosted him or her, and will be able to tender that statement in evidence to prove that he had in fact said so in his earlier statement to the police, and that he's not just making this up now for the first time when he's giving evidence. I hope I've been able to explain that, Mr. Speaker. So it's that's the issue as it relates to recent fabrication. Mr. Speaker, the proposed Section 33D provides for additional requirements for admissibility of multiple hearsay statements, being statements not made in oral evidence, but are relied on as evidence of the matter stated in it. This section defines a hearsay statement, Mr. Speaker, and provides that a hearsay statement may only be used where it is admissible by virtue of one of the earlier sections in the bill. Mr. Speaker, the proposed section 33E in the bill provides for the use of documents produced as exhibits and that they may only accompany the jury for their deliberations where the court considers it appropriate or all the parties to the proceedings agree that it should accompany the jury into the jury room. So, Mr. Speaker, again, there might be an incident where pictures were taken, there were photographs and other exhibits, documents. Usually when the jury retired to the jury room, they are not allowed to take these things with them to consider their verdict. This is now saying that clearly, in the interest of justice, it would be helpful for the jury to be able to have these things in the jury room to look at, consider, and go through. And so this is really just assisting that process by saying the documents or the exhibits will be able to accompany the jury into the jury room if they so request or all the parties agree and the court considers it in the interest of justice to allow the jury to have those exhibits in the jury room. Mr. Speaker, the proposed section 33F provides for the issue of credibility to apply wherein certain statements are admitted in the absence of oral testimony, Mr. Speaker. And the proposed section 33G, Mr. Speaker, provides for the court to stop the case where the court considers that the evidence is unconvincing and it would be a waste of time to admit the statement or the evidence given that it has very little or no probative value, Mr. Speaker. They can do that unless it is, of course, oral evidence being given in a trial. But if it is, again, evidence that is contained in a document or some other form, and the court takes the view that at its highest, this evidence would make no difference to the trial, and it's a waste of time to admit it in evidence, it has no probative value whatsoever. The court has the power. Sorry, and that is the only evidence on which the Crown or the other party seeks to rely. The court has the power, Mr. Speaker, to say in light of this unconvincing evidence, it would be a complete waste of time to proceed with this and take the initiative to stop the case then and there. Mr. Speaker, the proposed section 33A provides for the court to have a general discretion to exclude evidence, Mr. Speaker. So, as it is now, the court has the power to say that the evidence is unfair and the prejudicial nature of the evidence outweighs what is called the probative value. So in all the circumstances, though the evidence has some weight, some validity, it would be terribly unfair in all the circumstances to admit that evidence. And so it is going to be excluded. Mr. Speaker, the only other provision left in the bill is that to do with transitional provision, which speaks to cases that are currently before the court when this law becomes evidence. Sorry, when this bill becomes law, Mr. Speaker, I'm sorry. When this bill becomes law, if and when it does become law, it would apply to cases that are currently before the court so as to allow, where necessary, where possible, an accused person to benefit from the favorable provisions in the bill itself, Mr. Speaker. Mr. Speaker, I hope I've managed to explain it in a way that members could follow, and I will certainly commend the bill to honorable members.
Does any other member wish to speak? The Honorable, the Acting Leader of the Opposition.
Thank you, Mr. Speaker. I'll be very brief with my comments. First, I want to say that clearly I don't see any reason why the opposition wouldn't support this bill, these changes. From what I can tell, it's bringing our laws in line with what has become the standard, in particular the Criminal Justice Act in the UK. I think it's very important, Mr. Speaker, that these changes are made. I recall one case years ago where an individual had lent money to someone, and that person then paid him back. And, he thought that was the end of it. However, the funds had come from, he didn't verify the source of funds, put it that way, for the money being paid back. Turns out that person had stolen the money. So he was called to court years later when charges were made, and the person had to appear as a witness. And in the course of giving his testimony, because it had been several years and a lot had transpired since then, he'd forgotten about it, he left out in his testimony that the person had originally borrowed the money from him, and simply said to the judge, that when he received the money back, he spent it. The judge then turned to the prosecutor and said, "Has this witness been cautioned?" So simply because the person's memory had faded and they had forgotten all the details of what had happened and didn't include it in their testimony, and the person didn't have the benefit, Mr. Speaker, of looking at his previous statement, he almost got himself in some serious problems. So it is important that especially that provision. Yeah, go in as a witness and come out as a person who could potentially be going to prison. So it is important that we put these changes into the law. I think it would also assist with the delivery of justice in a lot of instances where things happen and over time people's memories fade. I want to add one query, and I've seen it done this way in the Criminal Justice Act as well, so it may not be an issue. However, where it says a person giving oral evidence in criminal proceedings about any matter may, and it goes on to say, there's a section A, subsection A, that said that person states in the person's oral evidence that the document records that person's recollection, and there's a B, and then where it says where, and then you have in section 2, A, B, and C. A starts off by saying a person given oral evidence in criminal proceedings about any matter has previously given an oral account of which a sound or video recording was made, and that person states in that evidence that the account represented that person's recollection of the matter at the time. Now, in every other subclause there, it says that person, that person. This one starts off by saying A. I think I'm reading that as when it says a person, that it could be any person, rather than specifically that person's previous statement or document. So I don't know if that's an error or something that needs to be changed, but it could be interpreted, in my view, as being a bit too open and allowing the admission of someone else's recollection to remind a witness. So that's the only question I had, Mr. Speaker. And again, I think there's no issue with the opposition supporting this bill. Thank you.
Does any other member wish to speak? The member for East End.
Thank you, Mr. Speaker. Mr. Speaker, I won't be long either, but despite the acting leader of the opposition saying that the opposition doesn't have much problems with supporting it, I believe that there are some things that I would like the Attorney General to clarify during his response as well. I heard in his presentation of the bill, he spoke of the lack of need now for the provision for adverse inference because it's in the police law. Mr. Speaker, I and the now Premier fought tooth and nail to keep this provision out of the laws in this country many, many years ago, many moons ago, I should say, but we were unsuccessful in our efforts. What's that? At the law. Anyway, at the time, Mr. Speaker, they told us that it was a provision that was put in place in England, and we were only following suit. We argued on the basis that it was encroaching on one's right if the police cautioned him that he had a right to remain silent, and then when he remained silent, you inferred you had an adverse inference to him remaining silent. The fact that it was in the evidence law and then put in the police law meant that the police, when that person was arrested and didn't say anything, that inference resulted in that person being warned of prosecution and then sent on to the DPP, I would suspect, to be prosecuted. And then the DPP would rely, I assume, or rely on that provision being in the evidence law to be able to prosecute. I'm not saying other evidence was not overwhelming, but certainly in that instance, it would have to be there for the prosecutor to point out to the jurors and the judge that they could infer such adverse inference. Now, if it's no longer in the law here, I wonder if there's any need to have it in the police law. I wonder if there's any need to have it in the police law, where the police, to what benefit would the police infer an adverse inference? What would that benefit the police to be, because the person remains silent after being cautioned that they do not have to say anything, whatever they say is going to be used against them, may be used against them, in the absence of it being in the evidence law. What would the prosecutor turn to the jurors and say? Because the one in the police law is only for the police to infer. The one in the evidence law is for the judge and the juror to infer the adverse inference. So if the Attorney General could do that, I could explain that aspect of it. I would appreciate that, because this has rested on my mind for a very long time. On the matter of showing a witness their evidence, their statement. And I understand we're trying to make it now that so that they can refresh their memory but hasn't that been a practice, Mr. Speaker, in all matters relating to criminal suits? Especially if the case has gone on for a while, usually I guess discovery would allow the defense to get those witness statements. And prior to court, they would show their witness or the accused, who can be a witness, the witness, the evidence, statement. I wonder, Mr. Speaker, if that was illegal. Obviously, I don't think that would be illegal. Is it that this carries it that much further to be able to do it inside the court? In the past, was it not done inside the court as the witness with or to a witness with their statement? I don't understand the actual need to have it in law if it's a common practice now. Oh, so you're trying to get rid of common law, so there's no mistaken or argument about it. Now we get into the crux of the matter. It is always interesting to be stupid and ask stupid questions. I see. Pardon me? Okay. All right. So you notice I read it, right? Okay. You expected me to? Really? Mr. Speaker, I don't have a problem with it, but I do know that a lot of these changes and these laws are motivated by personal needs to get prosecutions completed. And I appreciate that. I understand that. And I'm not on the side of any defense lawyer or anything like that. But I just want the Attorney General to explain those couple of things. Why is it that the inference is taken out here, adverse inference is taken out here, and is still required in the police law?
The member wish to speak? Does any other member wish to speak? Calling the Honorable Attorney General to wind up.
Thank you, Mr. Speaker. Mr. Speaker, by way of clarification, there are a couple of issues that the members touched on. The first one is the observation by the Honorable Acting Leader of the Opposition about the language used in 33A 2A, where it speaks about a person. Mr. Speaker, if the Honorable Member look at the way the section is structured, 33A, 1A, B, 33, 2, A, B, C. It is really the reason why 32A begins with the word a person is really because, Mr. Speaker, it is a continuation of 33A1, so it's really a continuum, having spoken or referenced the person in 33.1A. Mr. Speaker, it's mentioned about that person, and where a person giving oral evidence in criminal proceedings about any matter has previously given oral evidence. It then, Mr. Speaker, is seeking to refer to the first mentioned person. Now, having said that, Mr. Speaker, it wouldn't be inappropriate to use the word that person again, okay? So we might certainly look at it because it might flow better in terms of cohesion. So we'd certainly take a look at it as a typo. Mr. Speaker, in respect of the observations made by the Honourable Member from East End, there are two related matters. The first, Mr. Speaker, is when the police arrest an accused person, they often administer what is called a caution. And that is, you're not obliged to say anything. Having put the allegation to the person, they would then say you're not obliged to say anything. But whatever you say may be taken down in writing and may be given in evidence at your trial. And that, Mr. Speaker, is invariably meant to capture instances where the person might confess to the crime. So if having cautioned that person, having read the caution to that person, I think it's called Miranda right in the United States. If having administered that caution, the person then goes on to say, "Officer, I am very sorry, but I never meant to kill him, or I was upset, or something." All of that will be taken down in writing and will be given evidence at the trial. Now, Mr. Speaker, the importance of that is that because the way the law is structured, if it turns out at trial that the person makes what is called an incriminating statement when the police spoke to him or her initially, and it was clear to the police that the person was about to confess or might confess, and the police failed to administer that caution, that failure, Mr. Speaker, might render that statement, even though it was an admission of guilt, that failure by the police to caution the person might render that admission inadmissible. So the judge might disallow that statement from being provided in evidence, because the judge says, well, experienced police officer, you should have cautioned this person. You failed to caution the person, and that is inconsistent with the judge's rules. So the statement is rendered inadmissible. Once a person is cautioned, it provides a legal basis, a legitimacy, for allowing the confession into evidence. And then it becomes a matter of the jury as to what weight to make of it and whether to believe it or not. So that's the purpose of that. And that transpires when the person is arrested and, as we say, first taxed with the allegation. That's the thing. The second aspect of it, Mr. Speaker, is, as is dealt with in the police law, which is section 149, and the marginal notes reads, effect of accused silence at trial. At trial, during the trial. And Mr. Speaker, the significance of that aspect of it is that, and I just read the section for what it said, for what it's worth, so that members could follow. The section says, Mr. Speaker, in 149.1, it begins, at the trial of any person for an offense. Subsections 2 and 3 apply unless A, the accused's guilt is not in issue, or B, it appears to the court that the physical or mental condition of the accused makes it undesirable for him to give evidence. The person does have the mental capacity. But subsection 2 does not apply if at the conclusion of the evidence for the prosecution, his attorney at law informs the court that the accused will give evidence, or where he is unrepresented, the court ascertain from him that he will give evidence. Translation, Mr. Speaker, at the end of the prosecution's case, the prosecutor sits down, and the court will call upon the accused person and say, the prosecution has now given its evidence. Basically, it is your turn. Are you prepared? Are you going to give evidence, or are you going to rest? If the person says, I'm prepared to give evidence, then the person will be sent to the witness, asked to go to the witness box. But usually, Mr. Speaker, where the person is represented by a lawyer, once the Crown closes its case, that person's attorney will say to the judge, my lord, my client doesn't intend to give any evidence. And so they move straight to what is called addresses, and so. Or the attorney might say, my client wishes to give evidence, in which case he will go into the witness box to be sworn. Now, why this becomes relevant, Mr. Speaker, is because of the next section, subsection 2. It says where this subsection applies, the court shall, at the conclusion of the evidence for the prosecution, satisfy itself that the accused is aware that the stage has been reached at which evidence can be given for the defense, and that he can, if he wishes, give evidence. And this is the part, Mr. Speaker. And that if he chooses not to give evidence, or having been sworn without good cause, refuses to answer any question, that it will be permissible for the court or the jury to draw such inferences as appear proper from his failure to give evidence or his refusal without good cause to answer any question. Where this subsection applies, the court or the jury, in determining whether the accused is guilty of the offense charged, may draw such inferences as appear proper from the failure of the accused to give evidence or his refusal without good cause to answer any question. So, Mr. Speaker, once the prosecution closes this case, depending on the cogency of the evidence, the court ruled that there's a case to answer, if there's a no case submission, and one would have expected that the accused person would have wanted to give evidence, as they say colloquially, to explain his side of the story. And he, for whatever reason known to him, says, I am not going up there to give any evidence. I don't have anything to say in my own defense. Could be that he probably is afraid of being cross-examined by the prosecutor. Or, or it could be innocence, fear of public speaking. It could be any number of reasons. But if it is that you would have expected, if it is expected that you would have gone, if it is expected that you would have gone and give evidence in your own behalf, state your side of the story, and you chose not to do so. What this is saying is that the court or jury might ponder, why is it that he refuses to give evidence? Refuse to give evidence.
You know what Grant used to say? Tell him what Grant used to say.
Mr. Speaker, Mr. Speaker, yeah. Or if he gives evidence on his own behalf and is asked a question by the prosecutor, which a reasonable person would have expected him to proffer an answer to, and he chose not to answer that question, when the average or reasonable person would have, then the jury can ask, or the court may ask, well, why did he not answer that question? It is so straightforward, you'd have expected him or her to have an answer. Mr. Speaker, in those circumstances, what the law is saying is that the court can draw whatever inference they properly think could flow from that. Now, let me just caution that the law is not saying, Mr. Speaker, that you can be convicted simply because you refuse to answer the question. Or you cannot be convicted simply because you choose not to give evidence. If you choose not to give evidence in your own behalf, and the issue of proper adverse inference comes up, you can only be convicted if the court and or the jury goes back and examine the prosecution's case and say to themselves, on the prosecution's account, we are satisfied that you're guilty. These allegations are very cogent. You never give an explanation, so we are left with one side of the story, and the only side we have here is the prosecution's account, which has not been rebutted. And if the jury feel reasonably sure about that, then you can be convicted. Right. Right. But the judge will always warn about adverse inference, that you cannot use just adverse inference to convict a person. You must be satisfied that there are other evidence which, when examined and taken in its entirety. Thank you very much. But, Mr. Speaker, I know the member's concern. The member's concern is that on the face of it, it seems inherently unfair. Absolutely. But it is not unfair because it is not the only basis on which you're being convicted. You cannot be convicted simply because you refuse to give evidence. It's your right not to give evidence in your own behalf. And so you can only be convicted if there are other evidence there to convict you. Burden of proof on the prosecution never shifts. It remains right there throughout. That's right. But that's why you tried. That's all it is. So, right. So it is important that we clarify these things. I understand the member's concern. But as I said then, in 2010, when I was doing the police law, and I said now, it has gone to Strasbourg, the European Court of Human Rights, and they have confirmed that it is not a breach of one's human rights to draw an adverse inference against them. Because of duplication. You're not losing, you're contributing to the process. To the process. Yeah, thank you. So, I mean, your finger... Thank you, Mr. Speaker. Your fingerprints are going to be all over this as one of the lawmakers who made that. So, well, there you go. The conversion on the road to Damascus was not unique to the Apostle Paul.
It is Friday evening.
Thank you, Mr. Speaker. So, Mr. Speaker, I hope I've been able to clarify the points for the honourable members, and I certainly commend this bill, this very important piece of legislation, to all honourable members of this House. Thank you, sir.
The question is that a bill shortly entitled the Evidence Amendment Bill 2018 be given a second reading All those in favor, please say aye. Those against? The ayes have it. The Evidence Amendment Bill 2018 has been given a second reading.
The Freedom of Information Amendment Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. B. Mr. Speaker, I beg leave of the House to move the second reading of a bill, the long title of which is a bill for a law to amend the Freedom of Information Law 2018 revision to clarify and modify the scope of access and restricted access to certain exempt records under the law and to make provisions for the incidental and connected purposes.
Bill has been duly moved. Is the Honorable Attorney General speaking there too?
Thank you, Mr. Speaker. Yes, Mr. Speaker. Mr. Speaker, this bill seeks to clarify and modify the scope of access and restricted access to certain exempt records under the Freedom of Information Law, and to make provisions for, as I said, incidental and connected purposes. Mr. Speaker, this is the first substantial revision and update of the Freedom of Information Law since its approval back in 2007. And it should be noted, Mr. Speaker, that Section 58 of the law requires it to be reviewed from time to time, and therefore this amendment bill will serve to bring the government into compliance with this requirement, Mr. Speaker. Mr. Speaker, it should also be noted that this bill concludes and builds on work that was first started under the work of the FOI Committee of the Legislative Assembly back in 2011-2012, which considered a number of issues at that time, Mr. Speaker. Mr. Speaker, at that time, the Committee of the House looked at submissions from the Information Commissioner. We also examined submissions from the Freedom of Information Unit. Mr. Speaker, we had input from the public, and we had input, Mr. Speaker, at the time from the Office of the DPP. So, Mr. Speaker, this bill seeks to take forward the work of that FOI committee, along with any necessary updates, Mr. Speaker, in order to accommodate new key developments such as new data protection law and the whistleblower protection law. Mr. Speaker, it is also meant to reflect input from the elected government, updated input and recommendations from the Office of the Ombudsman, the FOI unit, the information managers throughout government, and to reflect lessons learned, Mr. Speaker, understandably, since the implementation of the law back then. So, Mr. Speaker, I will now speak to the nature and intent of the proposed changes as outlined in each clause of the bill, Mr. Speaker. Mr. Speaker, Clause 1 of the bill provides the short title and commencement. And here, Mr. Speaker, it should be noted that this clause proposes to create the facility for Cabinet to vary the date of commencement of different sections of the law. This provision, Mr. Speaker, is of immediate importance because the Data Protection Law 2017 is scheduled to come into effect later next year. Mr. Speaker, changes proposed in this amendment bill include a repeal of various sections relating to matters that are more properly and appropriately dealt with under the Data Protection Law, and therefore it is important for the commencement of this bill, or sections of it, Mr. Speaker, to coincide with the commencement of the Data Protection Law. Mr. Speaker, certainly as it relates to aspects of it dealing with personal information. Mr. Speaker, if I might just observe here that the Freedom of Information Law, the Data Protection Law was initially meant to come into effect early next year. Mr. Speaker, a decision has now been taken that, among other things, more time is required for data controllers and others to get up to speed and put the necessary administrative framework in place to give effect to the law. And those in industry who are going to be, in the wider public who are going to be impacted, Mr. Speaker, some of them are wrestling with other competing initiatives, which understandably sort of required them to focus their effort and energy elsewhere. So, Mr. Speaker, after careful consideration, the government has taken the view that it would be appropriate to defer the coming into effect of the Data Protection Law until September next year. So, at the appropriate stage, we'll be issuing an official release via the Government Information Service to confirm that. But, Mr. Speaker, the thinking at the moment is that the law will come into effect. Instead of January, it will now come into effect in September of 2019. Mr. Speaker, Clause 2 seeks to amend Section 2 of the Principal Law by deleting the definition of minister responsible. It's a minor amendment, if I might say so, sir, and substituting the definition for minister to mean minister or the official member responsible for a public authority that holds relevant records. Mr. Speaker, Clause 3 seeks to amend Section 3 of the law in subsection 1 to clarify that the FOI law applies to the office of the governor, but excludes exempt matter held by the governor's office, as stated in Section 3.5d, records which pertains, Mr. Speaker, which pertains to record that belong to the government of the United Kingdom of Great Britain and Northern Ireland. So, Mr. Speaker, let me just clarify there. The governor's office has always treated the law as applying to that office, but the law specifically provides that, or expressly provides that it doesn't bite on records that are held in the governor's office that belongs to the HMG, UK government. Thank you. That belongs to the United Kingdom government. Mr. Speaker, this is, what we're doing here is put it in the law expressly to say that it applies to the governor's office, and of course reconfirm that it doesn't bite on records that are held in the governor's office in respect of the United Kingdom government. Of course, Mr. Speaker, we all know in this chamber that if someone in the Cayman Islands needs documents from the United Kingdom, Foreign Commonwealth Office or someplace, they can make a Freedom of Information request directly to the UK under their Freedom of Information law, and it will be honored. In other words, the request will be processed. Yeah. So the persons from here have done that numerous times. No. You can apply directly to UK for records under the FOI law. Huh? No, it's once this record is not exempt, then you'll have it. Mr. Speaker, Clause 3 also seeks to amend Section 3.5 to provide that the law does not apply to records held by the Cayman Islands Stock Exchange or to records obtained or created by the Office of the Ombudsman in the course of carrying out its functions. Both exemptions, Mr. Speaker, of course, are subject to subsection 3.6, which is amended to clarify that the law applies to the administrative records of those two public authorities. Clause 3, Mr. Speaker, further seeks to amend Section 3.8 to include the entities charged with responsibility for customs and immigration matters. Also, Her Majesty's Cayman Islands Prison Service, the Financial Reporting Authority, and the Tax Information Authority, within this, to include those within the scope of security intelligence services, Mr. Speaker. The effect of this amendment is to provide that the law does not apply to these agencies in respect of their strategic or operational intelligence gathering activities referenced in Section 3.5 of the law. Mr. Speaker, Clause 4 seeks to amend Section 5 of the law to provide that the information to be published by an authority shall include such particulars as may be prescribed under the law. Clause 5, Mr. Speaker, seeks to amend Section 6 in subsection 2 to permit the extension of the exemption by the Ombudsman where it can be demonstrated that it reasonably continues to apply to the record. Currently, Mr. Speaker, the law provides that the exemption of a record shall not apply after the record has been in existence for 20 years unless otherwise stated. So, Mr. Speaker, this is saying that as it relates to declassification, so to speak, if after 20 years the the Ombudsman Office takes the view that it is still necessary to maintain the exemption, then they clearly will do so. Mr. Speaker, Clause 5 also seeks to repeal and replace Section 6.4b of the law to clarify that where a record is available to the public in accordance with administrative procedures established for that purpose, then access to those records shall be provided in accordance with those procedures. Clause 6, Mr. Speaker, seeks to amend Section 7 by inserting a subsection 3a, which makes provision for the applicant to consult with the authority with a view to reformulating an application in circumstances, Mr. Speaker, where the applicant has failed to provide sufficient detail to identify the record that he or she is seeking to access. This provision, Mr. Speaker, is formerly Section 11.1 and has been relocated because it is a better fit with this section, which deals with application for access. Mr. Speaker, what this is saying there is that oftentimes someone make an FOI request, and they have an idea what it is that they're seeking to access, what they're looking for. But the request itself is not properly crafted, it doesn't have sufficient clarity to identify the exact information that they're looking for. And what this is saying, Mr. Speaker, is that the law will allow for that applicant to speak to the agency or authority who's custodian of the record to help to clarify and craft the request so that it is clear what exactly that the person is after, the applicant is after. Clause 6, Mr. Speaker, also seeks to insert Section 3b, which provides for the 30-day timeline to be suspended during the period of consultation and the reformulation of the application. So time doesn't run, Mr. Speaker, when that sort of consultation is taking place. Clause 6, Mr. Speaker, further seeks to insert Section 6, subsection 6, to to provide that under Section 7, where a decision is taken by or in consultation with a minister, and in this case also an official member, a chief officer, or other superior in rank to the information manager, this must be noted on the written decision of on the application. And this amendment, Mr. Speaker, helps to clarify the FOI application process. Mr. Speaker, translation there. Invariably, when someone applies for information, a record at a particular ministry or department, depending on the sensitivity of the information, the information manager, who is invariably a support staff within the agency, is the person who processes or deals with that application. And if it's a routine record, they're more than likely free to release the record. But depending on the sensitivity, Mr. Speaker, otherwise of the record, the information manager might want to discuss it with his or her superior, all the way up to the chief officer, and sometimes with the minister and our official member involved. And what this is saying is that where that sort of discussion takes place, whatever the decision is when it's going out to the applicant, it must be clearly stated in the response that there was this consultation with the person, that there was consultation with the various officials. So after consultation with my chief officer, I decided to refuse the request, if that is the case. Clause 7, Mr. Speaker, seeks to amend Section 8 of the law in subsection 2 by shortening or seeking to abridge the period of time that a public authority has to transfer a request to another public authority from a period of 14 days to a period of 10 days. This change is proposed as transfer should occur before the time limit for public authority to acknowledge an application expires, and the timeline for acknowledging the application is within 10 days of the receipt. So, again, Mr. Speaker, where an FOI request is made to a department, they have 10 days within which to acknowledge receipt of the request. But sometimes the request is made to the wrong department, in the sense that it was sent to the AG's chambers, but it should have gone to the DPP's office. You're not supposed to send back the request to the applicant and ask him or her to forward it to the DPP's office. My office is supposed to send it to forward it on to the DPP's office for them to deal with it, and so. And it should be done within those 10 days, I think. Now it takes 14 days, you have 14 days within which to do so. Right. Have 14 days within which to do so. We're saying that you need to align the response time with the time that you used to transfer the request from my office to the DPP's office, 10 days as well. Mr. Speaker, Clause 8 seeks to amend Section 11 of the law by repealing subsection 1, which now appears in Section 7 as a new subsection 3A. Mr. Speaker, it was judged that Section 7, which deals with applications, was a better fit, as the subsection that is being relocated deals with the opportunity for applicants to consult with authorities to clarify and reformulate an application. Clause 8, Mr. Speaker, also seeks to amend subsection 11.3 by clarifying that the public authority is required to inform the applicant of its decision to defer the decision to defer within the time frame provided under subsection 7A 1E within 30 days, Mr. Speaker. Clause 9, Mr. Speaker, seeks to amend Section 14 of the FOI law by repealing subsection 2. The subject matter of this provision will be more appropriately provided for, Mr. Speaker, under the Data Protection Law 2017, whenever that law comes into effect. Mr. Speaker, Clause 10 seeks to amend Section 17 of the law to provide, among other things, that legal advice given by or on behalf of the Attorney General's Chambers or the Office of the Director of Public Prosecution is an exempt record. This amendment serves to relocate similar provision which is now found in section 21(1)(c), as this section, Mr. Speaker, which deals with records subject to legal privilege, etc., again provides a better fit. So it's better placed in section 17 as opposed to section 21(1)(c), where it's not. Clause 10 also, Mr. Speaker, seeks to insert subsection 2 to provide that records which are protected by legal professional privilege shall be exempt without any limitation as to time. Clause 11, Mr. Speaker, amends section 18 of the law in order to remove reference to official, Mr. Speaker, from in front of the word record. I think it's thought that is a bit superfluous, Mr. Speaker. This change will clarify that the term official record is not relevant within the context of the FOI law, which simply deals with records. It will also create a greater consistency in the way records are referenced throughout the law. Clause 12, Mr. Speaker, seeks to amend section 19 by repealing and substituting subsection 1 to provide that records of opinions, advice, recommendations, consultation, or deliberations are exempted if they are provided for or arise in the course of proceedings of Cabinet or the National Security Council or a committee thereof, or if they are provided for the governor or a minister or a member of Cabinet to formulate and develop government policy. Currently, Mr. Speaker, the exemption in 19.1 applies only to proceedings of Cabinet or a committee thereof. It should be noted that it could be inferred that there are some existing general exemptions that could apply to the additional matters exempted under this amendment. Example, Mr. Speaker, 21B, free and frank exchange of views, and 21D, prejudice to the effective conduct, of public affairs. So, Mr. Speaker, the effect of the amendment is to provide a sort of a bespoke exemption, specific exemption to these records so as to remove any doubt as to whether or not the exemption, in fact, applies to them. Clause 13, Mr. Speaker, seeks to amend section 20 of the law by deleting subsection 1C, which is the exemption provision which protects legal advice given by the Attorney General or the Office of the DPP. This provision, Mr. Speaker, is now included in section 17(1), and this is a section, Mr. Speaker, that specifically focuses on records that are subject to legal professional privilege. Mr. Speaker, Clause 14 seeks to amend Section 23 of the law to clarify that a record is exempt if its disclosure would involve the unreasonable disclosure of personal information of any natural person, whether that person is alive or not. Clause 14, sir, also seeks to insert a new subsection 5 to clarify that in determining whether disclosure of third-party personal information would be unreasonable, consideration should also be given as to whether the disclosure would be unauthorized processing under the data protection law. So you look at the data protection law to determine whether, pursuant to that law, this disclosure would be authorized or not. Clause 15, Mr. Speaker, seeks to amend Section 25 of the law by requiring that where a certificate in respect of an exempt record is issued by the governor or a minister responsible, the ombudsman shall be notified of the existence of this certificate. And this amendment will ensure that the ombudsman can report adequately to the Legislative Assembly on the issuance of such a certificate, Mr. Speaker. It also makes minor changes as a consequence of the change in the definition of minister responsible to, as I said, minister and official member responsible for the records. Mr. Speaker, Clause 16 seeks to amend Section 26 of the law by inserting a new subsection 3, which provides that, notwithstanding that a record is exempt from disclosure, access shall be granted to personal information where disclosure would be required under the data protection law. This clause, Mr. Speaker, also proposes consequential changes to Section 26.1 as a result of the deletion of 21C, Mr. Speaker, of the law, as I previously alluded to.
Mr. AG, Honorable Member, we've been past the hour 4:30. Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10.2 in order that the business of the House may continue beyond the hour of interruption.
Question is that standing orders be suspended in order for business to continue after the hour 4:30. All in favor? Aye. Those against? The ayes have it. Honorable AG.
Thank you, Mr. Speaker. Mr. Speaker, Clause 17 seeks to amend the law by repealing Part 4, which deals with the amendment and annotation of records and is inclusive of Section 28 through to 32. This amendment, Mr. Speaker, will remove references to the amendment and annotation of personal data, which now, Mr. Speaker, we think would be a better fit under the data protection law when that law comes into effect. Mr. Speaker, to somewhat similar effect is Clause 18, which seeks to amend Section 33 of the law by repealing and substituting this section in order to adjust the provisions governing an application for internal review. It will serve to remove reference, Mr. Speaker, to personal records, which will be, again, a better fit under the data protection law. Clause 19, Mr. Speaker, seeks to amend Section 34 of the law in subsection 1A by providing that the chief officer, in consultation with the minister, may conduct an internal review. This is an alternative to the minister conducting the internal review in relation to records exempt on the basis of national security, law enforcement, and national economy. So, so, Mr. Speaker, the minister and the chief officer, in consultation, can conduct an internal review where one is requested. Mr. Speaker, Clause 26 to amend Section 40 of the law by repealing subsection 2C as it relates to matters that pertain to applications for personal records. Again, this will migrate over to the data protection law when that law comes into effect. Clause 21, Mr. Speaker, seeks to amend Section 42 of the law by giving the Ombudsman the discretion to refuse to giving him the discretion to refuse to consider an appeal which, in the opinion of the Ombudsman, might be frivolous or vexatious. The provision also requires the Ombudsman, Mr. Speaker, to give reason for determining that an appeal is frivolous or vexatious. Clause 22 seeks to amend Section 43 of the law by, among other things, inserting a new subsection 5. Mr. Speaker, this section sets out that on appeal, the Ombudsman may also make any decision which could have been made on the initial application. And it is to be noted, Mr. Speaker, that this section is relocated from Section 42.4, as again, it is considered to be a better fit in Section 43, which deals with the whole question of appeals, Mr. Speaker. Clause 23, Mr. Speaker, is a minor amendment, seeks to amend Section 44 of the law by correcting the spelling as it relates to National Archive. Mr. Speaker, Clause 24 seeks to amend Section 45 of the law in subsection 2 to provide that where the Ombudsman requires to examine records that has been exempted under Section 19 of the law pertaining to cabinet opinions, advice, recommendations, consultations, or deliberations, Mr. Speaker, those records have to be examined at the Cabinet's office. The examination has to take place at the Cabinet's office. Clause 24 also seeks to amend subsection 3 to clarify that the production of a legally privileged record to the Ombudsman does not constitute a waiver of the privilege. So where the Ombudsman called for and is provided with a record which the government claim is privilege, carries legal professional privilege, the fact that the record is handed over to the Ombudsman's office does not mean, Mr. Speaker, that the government has waived legal professional privilege. So the Ombudsman is unable to release the record. Clause 25, Mr. Speaker, proposes to amend Section 47 of the law to clarify that a complainant may within 45 days apply to the Grand Court for leave to seek judicial review of a decision of the Ombudsman. This amendment serves to clarify the judicial review process, as Mr. Speaker, the law currently references right to appeal by way of judicial review, when in fact what is meant is to apply for leave to seek judicial review, Mr. Speaker. It's a subtle difference, but an important one. An appeal versus judicial review. The law currently speaks to the right to appeal by way of a judicial review. There are usually two separate things. An appeal and judicial review are usually two separate things. So what is really meant is that the person have the right to apply for judicial review. So we're just clarifying it to say you have the right to apply for judicial review of a decision, not to appeal. But, follow? Thanks. Clause 26 seeks to amend Section 48 of the law, Mr. Speaker, to clarify that the provisions reference to 45 days for appeals mean 45 calendar days, and as a consequential change arising from the amendments to the previous clause. Clause 26 also amends the section by deleting reference to appeals and replacing it with reference to application to seek judicial review. So there you go again, remember? Clause 27 seeks to amend Section 50 of the law to provide immunity to persons discharging their functions under the law. Mr. Speaker, it provides that no person shall be liable in damages for anything done or omitted in the discharge of their respective functions under this law, unless it can be shown that the act or omission was carried out in bad faith. This amendment addresses a gap, Mr. Speaker, in the law, as currently only the Ombudsman and her staff are afforded such protections under the law. Getting there, Mr. Speaker. Clause 28 seeks to amend Section 52 of the law by repealing subsection 3, which provides for adequate procedures for the correction of personal information by public bodies. And these matters, Mr. Speaker, will be accommodated under the data protection law. Mr. Speaker, Clause 30 seeks to amend the schedule in paragraph 2 by removing the reference to publication in the Gazette. The effect of the amendment is that a public authority is required within 12 months of the publication of their statements to cause the statement to be published on the government's or authority's website, or to publish the statement with such frequency or in such manner as may be prescribed. This amendment, Mr. Speaker, will provide a more efficient arrangement for the publication thereof, Mr. Speaker. So, Mr. Speaker, by way of summary, I would like to note that the vast majority of the proposed amendments to in this bill, probably about 80%, will serve to clarify legal meaning, also seek to improve upon existing wording, and to render the FOI process more efficient and effective, including, Mr. Speaker, changes that will ensure that the FOI law works well in conjunction with the companion legislation, the data protection law, whenever that comes into effect. Mr. Speaker, the remaining section, 20% or so of the changes, serve a variety of purposes. For example, Mr. Speaker, Clause 3 proposes to include additional agencies in the list of security or intelligence services, and we mentioned again customs and the Financial Reporting Authority. And Clause 5 proposes to permit an extension of the exemption of record by the Ombudsman, where it is demonstrated or can be demonstrated that it is necessary to continue to do so, Mr. Speaker, beyond the 20 years that is. Mr. Speaker, in my introduction, I stated that this bill concludes work that started quite some time ago, as far back as 2011. It also builds, Mr. Speaker, on the work begun around 2014 by a different project team. And Mr. Speaker, I would understandably therefore like to express my gratitude and thanks for the perseverance and expertise and invaluable support of the project team, Mr. Speaker, who has had what could only be described as the challenging task of completing this first comprehensive review of the Freedom of Information Law. Mr. Speaker, the project team consisted of Mrs. Mary Rodriguez, Chief Advisor to the Deputy Governor, Project Manager and Instructing Officer, Mr. Jan Libers from the Ombudsman Office, Ms. Nadira Lord from the Cabinet Office and the Information Unit, Ms. Aubrey Bodden, also from the Cabinet Office, Ms. Bethia Christian, and Ms. Maureen Benjamin from the Legislative Drafting Department, and former Crown Counsel, Ms. Rachel Hoare, Mr. Speaker. This project team, Mr. Speaker, has worked with the intent of helping policymakers to deliver a bill that proposes important improvements while staying true to the intent of the FOI law as expressed in Section 4, Mr. Speaker. And that intent is to the object of this law or to reinforce and give further effect to certain fundamental principles underlying the system of constitutional democracy, namely A, governmental accountability, B, transparency, and C, public participation in national decision-making. Mr. Speaker, I am pleased to recommend and commend the Freedom of Information 2018 bill to members of this House for its safe passage. I thank you, Mr. Speaker.
Does any other member wish to speak? The member for Bordentown West.
Thank you, Mr. Speaker. Okay. I won't be long, Mr. Speaker, but thank you, Sarge. Oops. Yeah. Mr. Speaker, when I first started reviewing this bill, the first thing that jumped out at me was the thickness of the green bill. It was thicker than the usual ones that I got in the pile. So I figured somebody did a lot of work into it. So one of the first things I had to do, Mr. Speaker, was get the original bill And I noticed the first one was passed in Law 10 of 2007, 3rd of September 2007. Then we made some changes again, Law 19 of 2012, done on 31st of August 2012, and then Law 27 of the 27th of March 2017. So 2007, 2012, 2017. I said, okay, a little 5 years in between. So I was a little bit kind of caught off when I saw where it popped up that we having all of these changes when we've been looking at this bill at a rate of every 5 years, and then it's been so thick. So I started looking at the old law and then comparing it to the new law. Now, Mr. Speaker, one of the things that really caught my attention off the bat was clause 3, but I won't go into that one yet. First was clause 10, where it says clause 10 seeks to amend section 17 of the principal law to provide, among other things, that legal advice given by or on behalf of the Attorney General or the Director of Public Prosecution is an exempt record. The Director of Public Prosecution is an exempt record, legal advice. So, Mr. Speaker, I went to look at the Constitution. Just wanted to make sure I'm making sure I have the right thing. Now, Section 56 of the Cayman Islands Constitutional Order 2009, Mr. Speaker, under the section of Attorney General says, there shall be an Attorney General of the Cayman Islands whose office shall be a public office and who shall be appointed in accordance with Section 106. Section 2 goes on to say the Attorney General shall be the principal legal advisor to the government and the Legislative Assembly. That fine, that makes sense. Section 57 of the Constitution, Mr. Speaker, deals with the Director of Public Prosecutions. And I actually read that section twice. And as I'm looking at it, it says, just briefly, there shall be a Director of Public Prosecution for the Cayman Islands, whose office shall be a public office and who shall be appointed in accordance with Section 106. The Director of Public Prosecution shall have power in any case in which he or she considers it desirable to do so, A, to institute and undertake criminal proceedings against any person before any court in respect of any offense against any law enforced in the Cayman Islands, B, to take over and to continue any such criminal proceedings that have been instituted by any other person or authority, and C, to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or herself or any other person or authority. Section 3 of the 57.3 goes on to say, Mr. Speaker, the powers of the Director of Public Prosecution under subsection 2 may be exercised by him or her in person or by officers subordinate to him or her acting under and in accordance with his or her general or special instruction. Section 4, 5, and 6 continues, but I won't read all of that. The thing I was looking for in that section, Mr. Speaker, was the Office of the Director of Public Prosecution giving legal advice to the government. And that's the part that kind of really jumped out at me at first, Mr. Speaker, because I couldn't help but wonder. I'm going to read it again. Clause 10 seeks to amend Section 17 of the Principal Law to provide, among other things, that legal advice given by or on behalf of the Attorney General and the Director of Public Prosecution is exempt record. Yeah, I'm just trying to figure out where the DPP had fit into that. That's the one thing. And I'm hoping that the Attorney General can, is it a situation, Mr. Speaker, where if it is that the legal advice that is given to the DPP, is that what is exempt, or is it the advice the DPP gives to the government? That's the one that's exempt. Yeah, that's the part, Mr. Speaker, that kind of really threw me off a little bit. Yeah, please. So that is in the police section. So it's not to the general government, not to ministers or anything. Okay, so I just wanted to make sure. No, man, I appreciate that. So, in other words, then the discussions between the DPP and the police will be exempt from police. Okay, and that's fine. I just wanted to make sure it's not the DPP wasn't giving advice to central government or ministers or anything like that. I just wanted to make sure. Okay, well, I will consider that as something from a security standpoint, which would have been exempt. So I'm fine with that. So Well, I mean, this is why we have these discussions. This is why we have committee stage, so we can, as we go through, we can look at the language if need be, just to make sure. They're legalese, I'm not. I just wanted to make sure from the layman standpoint. The other part, Mr. Speaker, that jumped out at me was Clause 3, that seeks to amend Section 3.8 by including the entities charged with responsible for customs and immigration matters. Her Majesty's Cayman Islands Prison Service, the Financial Reporting Authority, and the Tax Information Authority within the scope of security or intelligence services to which the law does not apply. Now, I am aware, Mr. Speaker, that the Customs and Border Protection law is also coming. And I noticed that in a subsequent bill that is before this House for consideration, that they refer to the Customs and Border Protection. The one thing, Mr. Speaker, that was a little bit off, and I just want that clarified also and make it completely clear, is that when you look at the original law, the original Freedom of Information law, and I just want to put it there for everyone listening, where it says Section Clause 3 seeks to amend Section 3.8. When you go into that section, Mr. Speaker, it speaks about the security intelligence services include the Cayman Islands Police Service, the Special Constabulary within the Cayman Islands Police Service, or the Department of Customs. I noticed that part of the law had nothing referred to with regards to immigration. And I notice now that immigration is included in this law in terms of immigration matters. Now, I believe immigration matters itself, Mr. Speaker, is very broad. And I think including immigration matters now as part of records that are exempt, I think that is actually not what the spirit of when this Honorable House first enacted this piece of legislation. I think that is one of the things that also needs to be clarified. It is too broad of an area, and this is a country where we're very dependent on the whole immigration issue. And to have immigration matters now exempt. Now, if it's just in the context of security or intelligence, then I believe, yes, something needs to be done, but I think it's something where the language needs to be a little bit more clear, and the intent of what is exempt is looked at more carefully. But as it stands right now, this is language that was not included in the original bill, that is now included, and I think this is one of the things that we just need to be mindful of. And I was just curious as to why we just don't, since we know we're going with the Custom and Border Protection, why don't we just change the name now as opposed to bring back an amendment later, because we know where that department is coming, or at least include language from now to refer to the Customs and Border Protection Unit. So, but it's in the advanced passenger bill. You use that language in the advanced passenger bill. I noticed that, that's why I asked the question. Because in the advanced passenger bill, you refer to the Customs and Border Protection Unit. That hasn't been created yet, but in this one, it's not referred, so I was just a little bit curious on that one. And yeah, well, so I noticed it was in one bill, but it was in another bill, so I was just curious. Since we know it's coming, why the language just wasn't, because it's in the advanced passenger bill, that language is already used. And then, Mr. Speaker, the other stuff I can pretty much raise with the Honorable Attorney General offline. The last one, Mr. Speaker, that just really jumped out was also on page 5 of the Green Bill, where it says Clause 12 seeks to amend Section 19 by repealing and substituting Section 1 to provide that records of opinions, advice, recommendation, consultations, or deliberations are exempted if they are provided for or arise in the course of proceedings of Cabinet or the National Security Council, or if they are provided for the governor or a minister to formulate or develop government policy. That last part, Mr. Speaker, was also included because in the original bill, the ministers were not included. Now, Cabinet was included, but information or provided to ministers wasn't there before. And I was just curious as to why ministers now are now being exempted when in the original bill it was not. So I'm trying to understand the spirit, because while I do accept that as things change, we will need to make certain changes to the bill, and the Honorable Attorney General did say in his contribution that some of these changes are going back as far as 2011, 2014 when they were looking at it. But I just need to make sure that we're not using language that takes away the spirit of what it was intended for. Now, Mr. Speaker, I'll be the first to admit that I've only made one Freedom of Information request in my entire life. Embarrassing as it is, I only did it sometime last year after being elected, and shameful as it is, I never got a response. Now, as a member of this House, I do have the ability to file questions which allows me to get more information than the general public would have. But it's important to me that the members of the public who can't ask the questions that we have the privilege of asking in this honorable House, at least they'll have access to this information. And it's important that as we go through and we make the changes with such changes like with the Customs and Border Protection coming on board, I mean, I can understand those changes. But the spirit of what this honorable House started with, I think we need to be careful that we don't lose the spirit. I am seeing bits and bits more, like some things are explainable, like the advice that the DPP gives to the police. That makes sense to some extent. You have lawyers can find a way to get what they want in court. But outside of that, we just need to make sure that we don't lose the spirit of what this law is for. As I said, it's about the public being able to keep their elected representatives and their government in check. And that in itself is a big part of democracy. So I just want us to make sure, because this is a lot of changes in one go for a very important bill. And I really wish I had more time in which to have gone through it bit by bit. But I mean, we had a lot of bills to go through in this session, but I just want to say to my colleagues in this honorable House that we need to look at some of these clauses and make sure we're not losing the spirit of what this law was intended to achieve, which is to make more information be available to the public to keep their government in check, which is an important part of our democracy. With that, Mr. Speaker, I will just close with that and just want to thank you very much.
Other member wish to speak?
Thank you, Mr. Speaker.
Member for Georgetown Central.
Mr. Speaker, I would like to concur with my colleague from Bontown West in respect to the concerns that he has highlighted. Because I agree with what he said, and I too am having the same problem in respect to time available to examine all of these very, very, very important changes. And I guess that's a result of having over 18 bills brought to this honorable House to be dealt with in 6 days. 21 bills, I was informed that the members on the opposite side of government whose responsibility it is to keep a close eye on any changes of this administration. I don't think we've been given a fair opportunity to do our job. But that being said, Mr. Speaker, I want to bring my thoughts to Clause 21 of the bill that talks about the ombudsman having the right to refuse an appeal if he finds it or she finds it to be frivolous or vexatious. Now, Mr. Speaker, I do believe that there are going to be circumstances like that that come up, and an option like this should be available for the ombudsman to ignore, if I dare say, or put it to a side rather than using up all the time of that office. But what I am concerned about is what are the guidelines that will be used by the ombudsman to decide whether something is frivolous or vexatious, or is this a matter of opinion, or is there some guidelines as to what can be determined as those two things that I am not aware of to see, because otherwise opinions then become subjective, and that leaves opportunity for, lack of better words, I think corruption would be a strong word, but a person who may find a loophole to try to avoid a right of a Caymanian to information by way of an appeal. So if the Honorable AG can just address that and highlight how that process would happen, that could give me some comfort in that respect. Besides that, Mr. Speaker, that's all I have to contribute to the debate of this bill. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The Honorable AG. Opposition spoke? See, the opposition spoke. You trained him? That what you got? That what you got to do? Train him? You never can tell.
Thank you, Mr. Speaker. Mr. Speaker, of course, I would like to start off by thanking honorable members for their contribution to the debate and the FOI bill, and I certainly value their input, Mr. Speaker. Mr. Speaker, as I mentioned to the honorable member, in a sort of voicey way, the DPP's office does in fact provide legal advice to the police and other law enforcement agencies on a daily basis, Mr. Speaker. And a lot of these advice on very sensitive matters for obvious reasons. So it is not unusual that there are lawyers, the people who work at the DPP's office are lawyers. No. Can't have it both ways. You agree that there should be a separation. Absolutely. Right. So they provide legal advice on matters relating to criminal conduct and criminal behaviors and all sorts of things.
That separation was used for prosecutorial matters?
Well, the advice is connected therewith, and relating thereto. Thank you. So they do provide that sort of advice, Mr. Speaker. And that is all that is exempted. The administrative records of the DPP's office, understandably, is open to FOI, so are those from the Office of the Attorney General. Mr. Speaker, I mentioned to the honorable members about the the name used in the immigration in the bill about custom and border. The correct way, Mr. Speaker, is that until and when you have a law to that effect, it is not appropriate to reference it in a bill. Right. The fact is, Mr. Speaker, that as not only is it incorrect, but it's presumptuous as well. We're presuming that the other bill is going to be enacted into law, and so if it is there, Mr. Speaker, it was inadvertence, and we will deal with that. But what we can do, we can use some language which says to the effect that if there's a name change or whatever, that the agency becomes.
When you do the revision, then what?
Yeah, that's right, and it can be swept up in the law revision exercise. So, Mr. Speaker, that's the only reason why I was trying to mention that. Mr. Speaker, the honourable member mentioned about the fact that the reference to immigration is very broad. But I think we had made it quite clear, Mr. Speaker, that it is in respect of their operational intelligence gathering activities, really. So the administrative record, for example, would not be caught. And if there are other records that have been FOI, for want of a better word, or there's a FOI request for, the Immigration Department would have to refer to the other exemptions under the law. But this is meant to address their operational intelligence gathering activities. And we can think of a lot of reasons why those records should be exempt from FOI, Mr. Speaker. Mr. Speaker, yeah, and I'm being reminded, Mr. Speaker, that there's a proviso there in Section 3.5 of the law, which addresses that issue. Yeah. Mr. Speaker, I think the member had some concerns about why a minister is now being brought into the fray, or into the scope, if you will. Mr. Speaker, I would only wish to observe that there are well-established constitutional as well as conventions. So, well, there are well-established constitutional principles as well as long-standing conventions, Mr. Speaker, as it relates to FOI legislation, to protect the integrity of policy-making process, Mr. Speaker, as it relates to government. And that is aimed at preventing disclosure which would undermine the process of decision-making. And, of course, Mr. Speaker, would have a chilling effect in that it would result in less robust as well as considered effective policies. Mr. Speaker, can you imagine if the deliberations and all the sort of considerations of ministers in policy-making deliberations were to be subject to FOI? Clearly, what the kind of chilling effect that would have is that ministers would go to meetings or wherever they are and just clam up, really, because there's really no protection as such. It doesn't necessarily follow, Mr. Speaker, that there's anything to hide, but it's the way that government works is that you ought to be able to have this kind of free and frank exchange of ideas so that you can make policies and so. And if every shifting impulse and all of that is subject to FOI law, then clearly that is going to defeat that and undermine that process. So, Mr. Speaker, that is the only basis on which that is being included. It's sensible and as it is understandable. And so, Mr. Speaker, the member from Central Georgetown, the honorable member from Central Georgetown, spoke about the ability of the ombudsman to refuse to hear an appeal where he deems it frivolous and vexatious. And he wants to know whether that is subject to, that could lead to some subjectivity, and whether there would be reasons for doing so. Mr. Speaker, he is correct that there's a bit of subjective, objective criteria involved there. The truth is that there are enough literature around, enough case law around that deals with the basis on which someone can decline to deal with something if they think it is frivolous and vexatious. We have that now where you can bar someone from bringing a claim in court if you think he's a vexatious litigant. There's provision to bar the person from doing so. I can think of a particular lady who managed to get onto that list in the last couple of years. But Mr. Speaker, the other safeguards, just to give the members some comfort, the other safeguards is that the amendment expressly provides that where the ombudsman makes a decision that it is frivolous and vexatious, he has to give reasons for doing so. So those reasons would be available to the public to see. And so that is the safeguards, Mr. Speaker, but it is not an unreasonable observation in the circumstances. And so thank you. Yeah. Yeah, no thanks. So, Mr. Speaker, unless there are other concerns, I hope I've managed to help to clarify some of the issues for honorable members, and I do thank them again for their input, and I would now commend the bill to this House for safe passage. Thank you, sir.
The question is that a bill shortly entitled the Freedom of Information Amendment Bill 2018 be given a second reading. All those in favor? Aye. Those against? No. The ayes have it.
Mr. Speaker, can we get a division, please?
Division clerk. You need to be.
Honorable Alden McLaughlin.
Aye.
Mr. Moses, Honorable Moses Cacarno. Honorable Juliano O'Connor Conley. Honorable Dwayne Seymour. Honorable Roy McTaggart.
Aye.
Honorable Joseph Hugh. Honorable Tara Rivers. Aye. Honorable Barney Bush.
Aye.
Captain Eugenie Banks.
Aye.
Miss Barbara Conley.
Aye.
Mr. David White. Aye. Mr. Austin Harris. Honorable Ezen Miller. Mr. Alva Saku.
No.
Mr. Kenneth Bryan. Mr. Anthony Eden,
No.
Mr. Christopher Saunders,
No.
Mr. Ard McLean,
No.
Of the division, 8 ayes, 4 noes, 1 abstention, 5 absentees. The motion is carried. The bill is carried.
the Prison Amendment Bill 2018, second reading.
Honorable the Attorney General.
Okay. Thank you, Mr. Thank you, Mr. Thank you, Mr. Speaker. Mr. Speaker, I beg to move the second reading of a bill entitled Bill for a Law to Amend the Prison Law, Law 14 of 1975, to allow for the temporary removal of prisoners from prisons for the purpose of interviews or inquiries and for incidental and connected purposes. Thank you, Mr. Speaker. Mr. Speaker, this is an extremely short bill. The background to this, Mr. Speaker, is that it is not unusual for persons who are incarcerated at the prisons to be potential witnesses in matters, in other matters, and such persons sometimes harbor reservations, Mr. Speaker, about giving interviews or giving statements to the police at the prisons for the obvious reason that some of them would be regarded as snitch, Mr. Speaker, or cooperating with the police. But the other reason, of course, Mr. Speaker, is that even where they are willing to go off-site, so to speak, to provide a statement, there's no legislative framework which allows the director of prison to give that sort of authority. Because once, as you know, Mr. Speaker, you might have been aware, once a prisoner is sent to Northwood by way of a warrant from the court, that's where he or she should be, and unless there's some good reason, then they ought not to be transferred off the premises. And so in this case, where the person is required to go off premises in the custody of another authority or body to provide that sort of a cooperation, the law is seeking to provide a legislative framework that would allow the prison director to expressly authorize the transfer, the temporary transfer to the police station or some other places to facilitate the witness, the person giving statements or otherwise cooperating with the police. That, Mr. Speaker, is the sole basis of this piece of legislation. It mirrors similar provisions in UK, in Northern Ireland and elsewhere. And so, Mr. Speaker, I ask members to support. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Call on the Honorable Attorney General to wind up.
Thank you, Mr. Speaker. Thank honorable member for their overwhelming support of this piece of legislation.
Question is that a bill entitled the Prisons Amendment Bill 2018 be given a second reading. All those in favor, please say aye.
Aye.
Those against? The ayes have it. The Prisons Amendment Bill 2018 has been given a second reading. The House now moves to committee. Please be seated. The House is in committee. I assume that, as usual, we would authorize the Attorney General to correct minor errors and any such matter in these bills.
You ready? The Stalking Civil Jurisdiction Bill 2018. Short title. Stalking. The stalking, this one. This one?
So we're doing all three.
We can start with stalking.
Mm-hmm.
Stalking, we start
Yeah.
with the top.
You gonna sit up?
You open, or
You got it?
And the bills too.
Bills, you want the bills? The bills. His bills.
So we
Clause 1, short title. Clause 2, interpretation. Clause 3, stalking. Clause 4, application for protection order. Clause 5, application for representative. Clause 6, involvement in proceedings where representative appointed. Clause 7, power to consider and make a protection order. Clause 8, ex parte application for protection order. Clause 9, protection order, conditions and offer, an offense. Clause 10, duration, discharge, and variation of a protection order.
The question is that clauses 1 to 10 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clauses 1 to 10 stands part of the bill.
Clause 11, court may order investigation to ascertain name and address of respondent. Clause 12, service provider to furnish particulars to court. Clause 13, attendance of witnesses. Clause 14, prohibition against publication of information. Clause 15, police may release information to enable application for protection order to be made. Clause 16, defense to provide that conduct was for lawful purpose. Clause 17, standard of proof. Clause 18, admission of evidence. Clause 19, applications may be heard together. Clause 20, vexatious proceedings. Clause 21, costs. Clause 22, civil remedy. Clause 23, appeals. Clause 24, rules of court. Clause 25, regulations.
Question is that clauses 11 through to 25 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clauses 11 through to 25 stands part of the bill.
A bill for a law to provide protection and remedies in cases involving stalking, to establish an investigative and complete procedure in relation to allegations of stalking, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. The title stands part of the bill.
The Penal Code Amendment Number 2 Bill, 2018. Clause 1, short title. Clause 2, repeal and substitution of Section 155 of the Penal Code, 2018 revision, watching and besetting. Clause 3, transitional and savings provisions.
Question is that clauses 1, 2, and 3 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clauses 1 through 3 stands part of the bill.
A bill for a law to amend the Penal Code 2018 revision to introduce the offense of stalking and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. The title stands part of the bill.
The Proceeds of Crime Amendment Bill 2018, Clause 1, short title. Clause 2, amendment of Section 4 of the Proceeds of Crime Law 2018 revision, powers, functions, and duties of Financial Reporting Authority. Clause 3, amendment of Section 5, Anti-Money Laundering Steering Group. Clause 4, amendment to Section 138, disclosure by the Financial Reporting Authority. Clause 5, amendment of Section 145 regulations.
The question is that clauses 1 to 5 do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clauses 1 through to 5 stands part of the bill.
There's a new clause.
Where is that now? You
1E.
you have a new clause?
Yeah, it's a 1E. Let me call. New,
Thank you, Mr. Speaker.
I thought you read it. You didn't read it.
New clause 1A, definitions and interpretation. Even 1A?
1A. You
Sorry, you
withdraw.
what? You withdraw it?
You-
Okay, thank you. Thank you, Mr. Chair. Mr. Chair, I had proposed a committee stage amendment in respect of this bill, but after further consideration, decided to withdraw the proposed committee stage amendment with the leave of the chair of the House.
Question is that the clause be withdrawn. All those in favor? Those against? The ayes have it. The clause has been withdrawn.
A bill for a law to amend the Proceeds of Crime Law 2018 revision to provide that the Financial Reporting Authority will not need to consult with the Anti-Money Laundering Steering Group to enter into certain agreements and arrangements with any overseas financial intelligence unit, to provide that the Financial Reporting Authority does not require the consent of the Attorney General for the disclosure of information to overseas financial intelligence units, to increase the powers of the Anti-Money Laundering Steering Group, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. The title stands part of the bill.
The Legal Association Miscellaneous Amendment Bill 2018, Clause 1, short title and commencement. Clause 2, general amendments to laws.
Which one is that?
Legal Association. So just two clauses.
The legal. Question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. Clauses 1 and 2 stands part of the bill.
A bill for a law to make consequential amendments to certain laws due to the merger of the legal associations, to provide for the regulation of continuing education for attorneys at law, including continuing education in anti-money laundering and counterterrorism legislation, and for incidental and connected purposes.
Question is that the title do stand part of the bill. All those in favor, please say aye. Those against? The ayes have it. The title stand part of the bill.
The Evidence Amendment Bill 2018, Clause 1, short title, Clause 2, amendment of Section 18 of the Evidence Law 2018 revision, accused persons, etc., as competent witnesses. Clause 3, amendment of Section 33, proof in criminal proceedings by written statement. Clause 4, insertion of new Section 33A to 33H, use of documents to refresh memory, inconsistent statements and other previous statements of witnesses, additional requirement for admissibility of multiple hearsay statements, documents produced as exhibits, credibility, stopping the case where evidence is unconvincing, court's general discretion and to exclude evidence. Clause 5, transitional provisions.
Question is that clauses 1 through to 5 do stand part of the bill. All those in favor, please say aye. Those against, the ayes have it. Clauses 1 through to 5 stands part of the bill.
A bill for a law to amend the Evidence Law 2018 revision to modernize the law in respect of the rules of hearsay evidence and witness statements, and for incidental and connected purposes.
Question is that the title do stands part of the bill. All those in favor, please say aye. Those against, the ayes have it. The title stands part of the bill.
The Freedom of Information Amendment Bill 2018. Clause 1, short titling commencement. Clause 2, amendment of Section 2 of the Freedom of Information Law 2018 revision, definitions. Clause 3, amendment of Section 3, applications. Clause 4, amendment of Section 5, publication of information by public authorities. Clause 5, amendment of Section 6, general right of access. Clause 6, amendment of Section 7, application for access. Clause 7, amendment of Section 8, transfer of request. Clause 8, amendment of Section 11, assistance and deferment of access. Clause 9, amendment of Section 14, grant of access. Clause 10, amendment of Section 17, records subject to legal privilege, etc. Clause 11, amendment of Section 18, records affecting national economy. Clause 12, repeal and substitution of Section 19, records revealing government's deliberative processes. Clause 13, amendment of Section 20, prejudice to effective conduct of public affairs. Clause 14, amendment of Section 23, records relating to personal information. Clause 15, amendment of Section 25, issuance of certificate re-exempt record. Clause 16, amendment of Section 26, some exemptions are subject to public interest tests.
Question is that clauses 1 through to 16 do stand part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. Clauses 1 through to 16 stands part of the bill.
Clause 17, repeal of Part 4, amendment and annotation of records. Clause 18, repeal and substitution of Section 33, application for internal review. Clause 19, amendment of Section 34, procedure for internal review. Clause 20, amendment of Section 40, reports. Clause 21, amendment of Section 42, appeal to ombudsman. Clause 22, amendment of Section 43, decision on appeal. Clause 23, amendment of Section 44, implementation of decision. Clause 24, amendment of section 45, ombudsman's power generally to investigate. Clause 25, amendment of section 47, appeal from ombudsman decisions and orders. Clause 26, amendment of section 48, decisions and orders of ombudsman binding. Clause 27, repeal and substitution of section 50, whistleblowers. Clause 28, amendment of section 52, maintenance of records. Clause 29, amendment of section 54, protection from liability, redefamation, breach of confidence, and intellectual property rights. Clause 30, amendment of the schedule. Information to be published by public authorities.
Question is that clauses 17 through to 30 do stand part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. Clauses 17 to 30 stands part of the bill.
A bill for a law to amend the Freedom of Information Law 2018 revision to clarify and modify the scope of the access and restricted access to certain exempt records under the law, and to make provision for incidental and connected purposes.
Question is that the title do stands part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. The title stands part of the bill.
The Prison Amendment Bill 2018, Clause 1, short title. Clause 2, insertion of Section 30A in the Prisons Law 14 of 1975, transfer of prisoners for interview, inquiries, etc.
Question is that clauses 1 and 2 do stand part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. The title.
A bill for a law to amend the Prisons Law, Law 14 of 1975, to allow for the temporary removal of prisoners from prison for the purpose of interview or inquiries, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Aye. Those against, the ayes have it. The title stands part of the bill. That's it.
Sir?
The House. Question is that the bills be reported to the House. All in favor? Those against? The House will now resume its sitting. The bills will be reported. Be seated. The House has resumed its sitting.
Report on bills. The Stock and Civil Jurisdiction Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled the Stock and Civil Jurisdiction Bill 2018 was considered by a committee of the whole House and passed.
The bill has been duly reported and is set down for the third reading.
The Penal Code Amendment Number 2 Bill 2018.
The Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled the Penal Code Amendment Number 2 Bill 2018 was considered by a committee of the whole House and passed without amendments.
The bill has been duly reported and is set down for the third reading.
The Proceeds of Crime Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled Proceeds of Crime Amendment Bill 2018 was considered by a committee of the whole House and passed without amendment.
The bill has been set down for the third reading.
The Evidence Amendment Bill 2018.
The Legal Association.
Yeah, sorry. The Legal Association Miscellaneous Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled Legal Associations Miscellaneous Amendment Bill 2018 was considered by a committee of the whole House and passed without amendment.
The bill has been set down for the third reading.
The Evidence Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that the bill entitled the Evidence Amendment Bill 2018 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported and is set down for the third reading.
The Freedom of Information Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled the Freedom of Information Amendment Bill 2018 was considered by a committee of the whole House and passed without amendments.
The bill has been duly reported and is set down for the third reading.
The Prisons Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to report that a bill entitled Prison Amendment Bill 2018 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported and is set down for the third reading.
Third readings. The Scranton Civil Jurisdiction Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled the Scranton Civil Jurisdiction Bill 2018 be given a third reading and pass.
The question is that a bill shortly entitled the Stalking Civil Jurisdiction Bill 2018 be given a third reading and passed. All those in favor, please say aye. Aye. Those against, the ayes have it. The Stalking Civil Jurisdiction Bill 2018 has been given a third reading and is passed.
The Penal Code Amendment Number 2 Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled the Penal Code Amendment Number 2 Bill 2018 be given a third reading and pass.
The question is that a bill shortly entitled the Penal Code Amendment Number 2 Bill 2018 be read a third time and is passed. All in favor? Those against? The ayes have it. the Penal Code Amendment Bill number 2, Bill 2018, has been read a third time and is passed.
The Proceeds of Crime Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill entitled Proceeds of Crime Amendment Bill 2018 be given a third reading and passed.
The question is that a bill shortly entitled The Proceeds of Crime Amendment Bill 2018 be given a third reading and passed. All those in favor, please say aye. Aye. Those against? The ayes have it. The bill, The Proceeds of Crime Amendment Bill 2018, has been read a third time and is passed.
The Legal Associations Miscellaneous Amendment Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill entitled Legal Associations Miscellaneous Amendment Bill 2018 be given a third reading and passed.
The question is that a bill shortly entitled The Legal Association Miscellaneous Amendment Bill 2018 be given a third reading and passed. All those in favor, please say aye. Aye. Those against?
No.
The ayes have it. The Legal Association Miscellaneous Amendment Bill 2018 has been read a third time and is passed.
The Evidence Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill entitled the Evidence Amendment Bill 2018 be given a third reading and passed.
The question is that a bill shortly entitled The Evidence Amendment Bill 2018 be given a third reading and passed. All those in favor, please say aye. Aye. Those against? No. The ayes have it. The Evidence Amendment Bill 2018 has been read a third time and is passed.
The Freedom of Information Amendment Bill 2018.
Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill entitled Freedom of Information Amendment Bill 2018 be given a third reading and passed.
Question is that a bill shortly entitled The Freedom of Information Amendment Bill 2018 be given a third reading and passed. All those in favor, please say aye. Aye. Those against?
No.
The ayes have it. Are you holding to the calling of the division? Do you still want a division, or are you satisfied with?
Yes, we would like a division, Mr. Speaker.
Honorable Alden McLaughlin, Honorable Moses Kirkconnell, Honorable Juliana O'Connor Connolly, Honorable Dwayne Seymour, Honorable Roy McTaggart, Honorable Joseph Hugh, Honorable Tara Rivers, Honorable Barney Bush, Captain Eugene Ebanks, Miss Barbara Connolly, Mr. David White, Mr. Austin Harris,
Aye.
Honorable Ezra Miller, Mr. Alva Saku,
No.
Mr. Kenneth Bryan, Mr. Anthony Eden, Mr. Christopher Saunders,
No.
Mr. Arden McLean,
Results of the division: 8 ayes, 3 noes, 1 abstention, 6 absentees. The bill is carried. The ayes have it. The bill entitled the Freedom of Information Amendment Bill 2018 has been read a third time, divided upon, but passed. Julie.
Mr. Speaker, I wish to move the suspension of Standing Order 47. Mr. Speaker, to enable the prison law to be moved at the same day.
Question is that standing orders 47 be suspended. All those in favor? Those against? The ayes have it.
The Prison Amendment Bill 2018.
The Honorable Attorney General.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that the bill entitled the Prison Amendment Bill 2018 be given a third reading and pass. And Mr. Speaker, will you leave before I take my seat? I just want to express my thanks to honorable members for accommodating these bills being dealt with in this way. Thank you very much.
The question is that the Prison Amendment Bill 2018 be given a third reading and passed. All those in favor? Those against? The ayes have it. The Prison Amendment Bill has been read a third time and is passed. No. Attorney?
First readings, the Immigration Transitional Bill 2018.
The Immigration Transition Bill 2018 has been read a first time and is set down for a second reading.
The Customs and Control Border Bill 2018.
The Customs and Control Border Bill 2018 has been Customs and Control. The Customs and Border Control Bill 2018 has been read the first time and is set down for a second reading.
The Formal Validity of Wills, Person Dying Abroad Bill 2018.
The Formal Validity of Wills, Persons Dying Abroad Bill 2018 has been read the first time and set down for a second reading.
The Companies Amendment Bill 2018.
The Companies Amendment Bill 2018 has been read the first time and set down for a second reading.
The Nonprofit Organizations Bill Amendment Bill 2018.
The Nonprofit Organizations Amendment Bill 2018 has been read the first time and is set down for a second reading.
The Banks and Trust Companies Amendment Bill 2018.
The Banks and Trust Companies Amendment Bill 2018 has been read a first time and is set down for a second reading.
The Cadet Corps Amendment Number 2 Bill 2018.
The Cadet Corps Amendment Number 2 Bill 2018 has been read a first time and is set down for the second reading.
The Advanced Passenger Information Amendment Bill 2018.
The Advanced Passenger Information Amendment Bill 2018 has been read a first time and is set down for the second reading.
The Roads Naming and Numbering Amendment Bill 2018.
The Roads Naming and Numbering Amendment Bill 2018 has been read a first time and is set down for the second reading.
The Limited Liability Partnership Amendment Bill 2018.
The Limited Liability Partnership Amendment Bill 2018 has been read a first time and is set down for the second reading.
The Stamp Duty Amendment Bill 2018.
The Stamp Duty Amendment Bill 2018 has been read a first time and is set down for the second reading. The Honorable, the Premier.
Thank you, Mr. Speaker. Mr. Speaker, I move the adjournment of this honorable House until 2 p.m. on Monday, the 19th of November.
Before we call the adjournment, just like to report to the House that Pat Hewlett has had her surgery in Miami and is doing well. Question is that this honorable assembly do now adjourn until Monday, God willing, at 2 p.m. All in favor? Those against? You wonder why?